Welcome back, everyone. We're going to move on to the next set of Supreme Court cases. My name is Scott Burow. I work with the Chicago firm of Banner and Witcoff, and we're here to discuss the Lexmark versus Static Control decision and the POM Wonderful versus Coca-Cola case. Both of these cases, as you might know, involve false advertising under the Lanham Act. And before we get into each of the cases, let me introduce our esteemed panel here. To my immediate left is Jameson Jones. He was counsel for static control components, and he is currently a partner at Bartlit, Beck in Denver. To his left is Thomas Saunders. He is counsel for POM Wonderful. He is a partner at WilmerHale in Washington, D.C. And last but not least is Professor Rebecca Tushnet from Georgetown. And Professor Tushnet co-authored an Amici Curiae Law Professors brief in support of neither side in the Lexmark case. Before we jump into these two cases, let me just briefly summarize them like we've been doing today. The first case is Lexmark versus Static Control. This is a Supreme Court case that was a 9-0 decision penned by Justice Scalia, the panel affirmed the Sixth Circuit and held that in order to sue for false advertising under the Lanham Act, the plaintiff must demonstrate that his interests were within the zone of interest protected by the Act, and that the plaintiff must suffer damage that is proximately caused by the defendant's breach of the Act. Under the court's newly fashioned test, Static Control, in this case, had a standing to sue Lexmark for false advertising. According to Static Control's complaint, Lexmark, who is a maker of printers and toner cartridges for its printers, allegedly misled consumers into believing that they were legally required to return their printer cartridges to Lexmark. Lexmark also sent letters to remanufacturers of Lexmark printer cartridges that allegedly falsely claimed it was illegal to make and sell refurbished cartridges, including using Static Control's components to refurbish Lexmark printer cartridges. Now, the second case we'll discuss is the POM Wonderful versus Coca-Cola case. And this case involved a dispute between competitors in the market for juices containing pomegranate juice. The Supreme Court, in an 8-0 decision penned by Justice Kennedy, actually reversed the Ninth Circuit and held that a false advertising claim under the Lanham Act based on the label of a beverage is not precluded by the Federal Drug and Cosmetic Acts, which prohibits a misbranding of labels. Misbranding of food and drink. The FDA regulations require disclosure of percentages of juice in a juice blend if the label only names the predominant juices, but the FDA doesn't pre-approve such labels and has limited resources for enforcement. The court found nothing in the FDA to suggest that it precluded private claims under the Lanham Act. Accordingly, POM, which produces pomegranate blueberry juice, was able to sue Coca-Cola for false advertising for prominently labeling its Minute Maid juice with the words pomegranate blueberry, even though it contains only 0.3% pomegranate juice and 0.2% blueberry juice, and 99.5% of other juices, including apple and grape juices. I believe there's an image of the Minute Maid label in your materials for you to look at. All right, with that as the background, and before we sort of jump into these two cases collectively and sort of the impact that both these cases will provide in this area, let's jump into the Lexmark case. And I would like to start first with Jameson. In Lexmark, the Supreme Court rejected the 3 tests of standing for false advertising that the lower circuits had previously used. One was a multi-factor test. The second one was the direct competitor test, and then the third was a reasonable interest test. The court fashioned its own test, which I indicated before was called the zone of interest test plus proximate causation. Do you think that the court's test is better in terms of serving the Lanham Act's goal of protecting persons engaged in commerce against unfair competition?
Yes, and Static Control advocated for the zone of interest test before the Supreme Court, partly because we think that that test focuses courts of appeals and district courts back on the statute, the text of the statute, and the history of it, better than some five-factor tests that often can become unmoored from the original purposes and motivating principles behind a particular statute. So we think it does. It ends up in application under the Lanham Act, giving a right of action to those who have a reputational interest in the subject matter of the false advertising. And I think that that's perfectly administrable and works fairly well to allow courts both the flexibility to provide causes of action in places where Congress would have given it, but also allows them to exclude it for parties who would be outside those within the zone that Congress did not want to protect.
Okay. And Professor Tushnet, how do you feel about the court's new fashion test? Do you think it serves the interests of the Lanham Act?
So I think it's clearly better than the Conti brothers' alternative, which is the five-factor test the court rejected. The question really is, what are courts going to do with proximate causation, which is an area where we all know proximate causation is kind of not exactly moral, but it's a determination that isn't about scientific causality. And so I think the real question going forward is, what are courts going to demand, say, of a competitor who has a 20% market share? Will they believe that that competitor is proximately harmed by false advertising by another competitor with 20% market share?
And just, I mean, the thing that I'm looking for on the proximate causation front is you have prior proximate cause cases that said normally we wouldn't go beyond the first step. So you're requiring some sort of direct connection. On the facts of this case, you had, because the refurbishers are all using static controls, there's a very, very, very high market share there. The court was able to say, well, in this case, anything that's going to deter refurbishment is going to therefore impact static control. And I just think that there is a big question mark in the middle between those two approaches that is left entirely to the lower courts in terms of how far beyond that first step of connection will go to recognize harm.
I agree that proximate cause is the most open-ended question out of this opinion. I think the Supreme Court was fairly clear that proximate causation is going to be a background principle for essentially all federal statutes. As I thought was probably clear from prior Supreme Court precedent, it's interesting the parallel between this and some of the RICO cases, where there was a whole series of RICO cases that the courts of appeals had decided based upon a doctrine that they called RICO standing. They said people who are too attenuated or are too far away from some pattern of racketeering don't have standing to sue. Those cases got up to the Supreme Court, and without mentioning any of the RICO standing cases or the language, the Supreme Court just decided we're going to call it proximate causation and send it back down. And so I think the RICO cases provide a pretty good analogy to what can be used in the false advertising context for who's going to have proximate causation and who's not going to be able to allege it or prove it. Those who have a reputational interest in the subject matter of the false advertising, I think, will be able to establish proximate causation generally. If you're a very, very small market player and somebody's only falsely talking about their own product, you might not be able to show that you're proximately harmed. But if somebody's talking falsely in a way that really affects the way that consumers or others in the marketplace perceive the qualities of your product, then you're going to have standing, or you're going to be able to allege proximate causation. Those who are harmed one step beyond those with reputational interests, say suppliers to static control, for example, who can just say that static control may lose sales, and so static control uses less electricity or other things like that, those types of injured parties will not be able to establish proximate cause, in my view. So I don't think it's really that hard to apply if you use, by analogy, these other areas of Supreme Court precedent.
Well, so I think that depends on what your sort of modal false advertising case is. So one thing that the court, I think, a little bit lost sight of because of the facts of this case is that the original cause of action is really for plaintiffs to go after defendants who are making false claims about their own products, right? In fact, by amendment, it was required to confirm that product disparagement was also available under the Lanham Act. I think that was the right course. And I think the cases, the circuits that believed that disparagement was available even before the amendment were right. But I am concerned. I actually do think that the person with the 20% market share has a perfectly important interest and, probably as much incentive as anyone could to go after false advertising of the touting oneself type. And we should worry about a standard that seems to give monopolists the strongest cause of action.
That makes sense to me. I don't think it's necessarily a matter of market share where the hardest questions come. It's perhaps defining the relevant market. That if Burger King, for example, for an example that came up at argument, is going to falsely advertise about its own products, Olive Garden, you might say, is in a different category of restaurant to be able to say that they've been proximately injured by the false advertising of Burger King falsely trumping up the Whopper. But McDonald's, likely Subway, others who are closer would have such an interest. But that's where the hard questions on the margin are going to be.
Well, to further that point, how far do we think we can take this? Do you think consumers potentially could have a cause of action, or is it going to be? Does it stop at a competitor, at the competitive level?
The Supreme Court was fairly clear that consumers don't have a right of action under the Lanham Act, and there was uniform circuit court precedent essentially saying that there was no standing for consumers under this act. I think that's a perfectly defensible line given the context of how the Lanham Act in Section 43A came to be, that it's part of an unfair competition statute. It was designed to give force to treaty obligations to protect those entering the U.S. markets and selling products. And there's kind of an explicit statement of purposes in the Act saying it's designed to protect those engaged in interstate commerce from unfair competition. You could also defend an alternate view because the statute says any person damaged has a right to sue, that it should mean what it says, but the Supreme Court has rejected that view.
It's the any person damaged that, as the outside observer, first looking at this opinion, the thing I was struggling with most on the zone of interest test is the opinion seems to be making this move to say we're wary of the language of prudential standing, because we don't want to sound like this is just prudence, we're making it up, that the courts are just declining to consider something in their jurisdiction. So they say we're going to determine the zone of interest by looking at the statute. But then what was unclear to me is you then have very broad statutory language in terms of any person. And what then, but the sense that we're going to limit that anyway. The zone of interest, we're going to look at the statute, but with this overlay of the principle of the zone of interest. And I guess I was wondering, what supplies the content there? How do you determine what's the zone of interest? Is this just text and legislative history?
I think it's text and context and the history of the statute. There are explicit purposes that were enacted as part of Lanham Act Section 43A that give a little bit of content. I think part of the problem is the Supreme Court has long history of saying that when Congress says any person can sue, they don't really mean it. They've done that in the antitrust statutes, under the Administrative Procedure Act. They've done it in a number of contexts, and the way that in a few contexts now, the court has dealt with that problem, is to say, we're going to look to the zone that of people, of interests that Congress was trying to protect in this statute. And the fact that it's part of a trademark and unfair competition statute kind of gives content to that test here to say it's about commercial actors who have reputational interests.
See, I don't find that fully satisfying because, among other things, the statute also lists a statutory purpose of protecting consumers. It seems like they are as entitled to the protections of the statute as anyone. And I should note also, consumers are engaged in commerce. Right? So if we are interested in protecting people engaged in commerce, it seems like both the person selling and the person buying are engaged in commerce. So I know why it didn't come out this way, but I think the court was kind of deliberately ignoring the other parts of the breadth of the statute, in part because no one was arguing to them that consumers should have standing. It seemed like an easy thing that everybody agreed on.
But the court could have said, we're going to leave that question for another day, and there's no split on the question, and so it probably never would have come back up to the court.
I mean, there are these occasional cases that one or two of them that have consumers have standing, or consumer groups. Interestingly, there's a post-Lexmark case allowing a company to pursue false advertising claims based on statements made to its suppliers, which seems like they're consumers, sort of consumers with standing, but it's also a disparagement case. So
there's a practical reason why I think it's fine to leave consumers out, and that is not necessarily textual, but there are state consumer protection acts all over the place that really give people protection from false advertising if they purchase a product that really harms them or is because of false advertising. There generally are state remedies. Those who are selling products across 50 states need to have generally a uniform federal remedy, and I think that's what Congress was trying to do in this statute.
The other part of the test was the proximate causation aspect, and we touched on that briefly, but a question for the panel is, do you think the new proximate cause sort of part of this test gives judges more discretion to throw out false advertising claims?
I don't think it gives any more discretion than the prior prudential standing tests did, especially those within kind of the Second Circuit, Sixth Circuit reasonable interest test, or the Conti brothers 5-factor antitrust test that Justice Alito had written. Those were so kind of insolubly vague, to use a term that's been bandied around today, that courts could decide, no, a particular interest is not reasonable in my view, or fails for one of these few factors. And I think proximate cause gives more content because courts have applied that principle and juries have applied that principle in many, many different areas. And yes, it's hard to define what is sufficiently proximate, but it's something that courts do on a regular basis.
Mm-hmm. Thomas or Professor?
Well, I think, it really interacts with the pleading standard. The real question is what courts are going to make people plead in terms of causation. So you have some courts that say, if you plead falsity and if you plead that, your competitors or whatever it is that you need to prove that you're within, the zone of people who could be harmed, then you plead you've been damaged, you've pled a fact, right? And then the rest remains for proof. Other courts are starting to be pickier and saying you need to plead some sort of fact about the damage. And I think we need, it would be nice actually to get some guidance about what it means to plead a fact now that we're in Iqbal Twombly world.
Don't you think it's sufficient to plead the mechanism of harm such that this false advertising deceives the consumers,
I think it is, absolutely. It's just the problem is there's not much consistency
right.
in cases.
And it's not going to be sufficient to just say I was proximately harmed. You got to show what mechanism of harm there is, and then it's for courts to decide if you prove that you were actually harmed through that mechanism, you're close enough to the relevant falsity.
Yeah, I agree. I just note that as an empirical matter, there's now a fair amount of divergence in the lower courts. And it usually reflects something about what they think about the merits of the underlying claim, which of course they have no facts to back up at that stage. Okay. Sorry about that.
Well, let's move on to POM Wonderful, and that way it'll have plenty of opportunity at the end for the audience to ask questions on both cases. And let me just throw this question to Thomas, excuse me.
It's Thomas.
Okay, thank you. Who is in the better position to enforce the false advertising provisions, in your view? Private party competitors or the FDA?
I mean, my view, it's certainly private party competitors, and I think you even saw the United States saying this in its amicus brief, that the FDA has a particular mission, is primarily focused on health and safety. It has limited enforcement resources and also limited information. It's not out there in the marketplace seeing these market dynamics at stake, and so the Lanham Act provides a sort of classic remedy from which the competitor, who is the one who's on the front line and is being injured and does have the strongest economic incentive to do something about it, to be the one to bring that into court.
Okay. Professor?
So I reject the framing of the question because the system only works if all entities have some role to play. So there are things that competitors will never sue about. For example, cigarette companies will never sue each other for making health claims. And in fact, you see empirically when the regulator shows less interest in something, private causes of action increase. So it happened in the 90s as the regulators pulled back. You saw a big surge in Lanham Act claims because they weren't paying any attention. And actually, as consumer class actions have decreased, you've seen the FTC sort of come in to fill some of that void. So I think they have different sources of expertise, and I'm wary of denigrating the FDA in the service of saying that POM should make its claim, which it should be able to.
This sort of follows up on that point. The question is, should we be as confident as the court was that allowing false advertising claims based on labels governed by the FDA is in fact complementary in purpose and not in conflict with the Lanham Act? Tom?
I mean, I certainly think that the court got it right on that front.
Right, they're complementary. One works with the other to some extent?
Yeah, exactly. And that particularly when you're looking at this regime here that the FDA is running, and I think the court was very careful to say in its opinion, this is not a pre-approval regime. This is not a situation in which the FDA is looking at every single label. And also it was looking at some of the guidance the FDA is providing in its own regulations, where the FDA's regulations are really expressing, if you do it in this way, then the FDA, for its purposes, might not be coming after you. But the FDA at the same time is encouraging you, but by all means, disclose more, say more, do it in a more transparent way if you want to. And so it seems like the FDA is consciously exercising its role in a way that is not getting at the particular harm to the competitor that you see here. And just to sort of provide a little bit more background on this, I mean, what you have in this situation here is POM Wonderful had made a big investment in a lot of research and advertising of its own around pomegranate juice, and it has 100% pomegranate blueberry juice, and talking about the antioxidant effects of that. And the competitive harm to them is when you have a competing product that says pomegranate blueberry, and then in much smaller letters, flavored blend of 5 juices, and is really much cheaper apple and grape juice. You have a competitor who's coming in there and it looks like it's the same product. Everybody thinks they're getting the premium pomegranate blueberry juice, but one can be produced much cheaper because it is actually apple and grape juice. And that, I think, is hitting POM in a way that implicates different concerns in terms of whether that is an unfair way to compete than the FDA's separate health concern, which is, are people really getting the particular fruits that they think they're getting?
Yeah, I would also add that the FDA has a particular interest in harmonization. So it's important for consumers in general to look at the panel, be able to compare different foods. And that's why we need uniform labeling rules. That's not a matter of pure deception. It's actually a matter of adding information into the market. And that concern gives rise to the FDA's regulations. But there's still a need not to deceive consumers.
I think this case was fairly easy based upon the court's FDA cases in terms of preemption, where they've said that state tort requirements different from pre-approved drug labels are not preempted and not in conflict unless the FDA has specifically required, essentially, a particular statement to be on a label. A state can't say you have to take that off. So it's a really stringent conflict preemption regime. And I think probably in this context, there would be room for such a specific conflict preemption argument that if the FDA requires a certain thing on a label for it to not be misleading, that tort suits or Lanham Act suits couldn't require that it be removed. But other than that, it's fair game.
The Ninth Circuit had worried that allowing private party suits would undermine the FDA's authority, and we sort of touched on this a little bit. Justice Kennedy's opinion, however, argues that competitors have a more detailed knowledge of the market. Tom, do you believe that Justice Kennedy was correct in that assessment?
Yeah, I think that's certainly right in terms of them being on the front lines and having this information. And to me, I think if you were to argue the other side of the case, it has less to do with undermining the FDA authority than with the interest in national uniformity. The sense that, well, what if one jury says this is misleading because you didn't put this larger, and another jury says this is misleading because you didn't put this larger, and you end up with this patchwork in which if you tried to comply with all those different standards, then there would be a mess. And so I think that what Coca-Cola, their main argument here was that the FDA could be that centralizing figure, could be that place where people could go and get one national standard. And the problem they had is that on these, although that might be a reasonable policy choice that could be made in terms of on the face of the statute and trying to reconcile these two schemes, these two statutory schemes, the court just thought that that wasn't the way that it had been set up by Congress.
Professor, do you have any thoughts on that?
So I think the FDA actually does know a number of things about the market, and this is my concern about not undermining the FDA, especially now that we're seeing all sorts of First Amendment claims being made against regulation. The thing that the FDA does that private parties generally don't do is they generalize. So we know that small print disclosures don't work. And the FDA and the FTC say that's a rule, right? So if we look at your small print disclosure, we don't need a survey to know that your small print disclosure didn't work either. And I think it's important to retain that capacity, even if we decide that we want more specific proof in private party cases. Although frankly, I think it would actually be just as persuasive in private party cases.
After POM Wonderful, is there any possible preclusion of false advertising claims related to labels governed by the FDA? Anyone have any thoughts on that?
And my answer is absolutely. There is an express preemption provision with respect to certain state law claims. And that one of the fights here was that Coca-Cola was trying to take a preemption provision that was specifically directed at the states and say this also applied to the Lanham Act, and the Supreme Court says, if anything, it's the opposite inference. They're doing one but not the other. And this was part of the court's explanation rationale too, is that in terms of the underlying substantive standard, that preemption is still in place and limits some of the patchwork problems if the states are going in entirely different directions. And I think one of the most interesting parts of the opinion is the discussion of uniformity. And I thought this has implications too for people who are interested in patent law, because the court was really making the argument that a standards-based approach in which you can have variance in the way that it's being applied by individual juries can still be considered a form of national uniformity as long as it's coming together in one statute like the Lanham Act, and so it is that one national standard. And so I think it was a sort of different twist. People often argue uniformity, as we heard earlier today. In some of the attorney's fees cases, one of the arguments for not having deferential review was we need the federal circuit to be centralizing this to achieve uniformity of result. And this was an example, I think, where it's acknowledging that even if you don't have uniformity of result, uniformity of the standard is itself a form of national uniformity.
My next few questions kind of relate to these two cases collectively and sort of the result or effect of these. Does anyone on the panel have any thoughts on whether we might see an uptick in cases filed under the Lanham Act based on false advertising, given, for example, the new standards set forth in the Lexmark case?
I think there will be a modest uptick. I don't think there's perhaps necessarily a huge difference between those whose claims should be allowed to go forward now than under prior precedent. I think the benefits of the Lexmark, static control v. Lexmark opinion is that it provides more guidance kind of generally for statutory interpretation than necessarily changes the outcomes in particular Lanham Act cases.
And I think there's a certain degree of litigation economics that's going to drive this, in the sense that it's just not going to make sense to bring cases over low-level harm, or to the extent we see those cases, maybe you'll see more of those in the context of overall litigation, where the two sides are at war over something else, and those claims are being thrown into the mix to have some sort of counter pressure. But I think it's telling that the cases you see here are ones in which the allegations, the advertising in the Lexmark case is really going to the core of what static control is doing, would have a big impact on its market. For POM Wonderful, it's having this product that's pretending to be the same, but that can significantly undercut you on price because it isn't. And so you just it has to get above a certain threshold of threat to you before you're going to invest the substantial resources in litigation.
So I would say I would also predict an uptick. So I'm struck by the similarity of the statements in the cases to things that get said in Daystar and Walmart on the opposite side. So Daystar and Walmart are cases where the Supreme Court sends a very strong signal. You've been interpreting the Lanham Act too broadly in trademark. And courts really, really pick up on it in cases that are not obviously the same case. And I think we're seeing a little bit of that already in terms of courts quoting Lexmark and POM, the parts about how broad the Lanham Act is in its false advertising provision in unrelated cases. So I think there is a certain amount of signaling going on.
And the fact that you had two opinions from the Supreme Court in one term just raises awareness about the statute. And I know there are companies who have thought about bringing claims just because that statute was the subject of some coverage.
Mm-hmm. And that gets to sort of my next question. These companies who, have now seen these decisions come out, do you think, you would advise them to take a close look at their labeling and their advertising to make sure that they're not, stating anything that they shouldn't be or representing something that might not in fact be a fully accurate representation?
Sure. I think companies should always, as a matter of prudence, take a look at whatever advertising they're putting out and make sure that they're comfortable defending it in court.
Well, we have a few minutes left for questions from the audience. Does anyone have any questions for our panel?
Will that have an impact in other areas of law that will expand the number of suits? One thought I
The Lexmark opinion is definitely designed to give guidance across federal statutes and essentially says, prudential standing no longer exists. We shouldn't give or deny a right of action based on standing in our prudence, but it just basically ends up being a similar inquiry with different words as to a pure matter of statutory interpretation about who Congress gave a right of action to. And so I think it's more of a shift in focus and shift in semantics than it is ultimately going to drive changes in outcomes. The one, what Professor Tushnet raised earlier, question is the proximate causation inquiry, where there are some statutes that just hasn't come up yet in the case law, and I was actually struck in reading the Lanham Act case law that it hadn't arisen more because the court has emphasized a few times that that's just a background principle of against which Congress legislates. And I think it'll be interesting to see what types of statutes that arises where courts and litigants hadn't thought to raise it before.
So I have a slightly different perspective. So first of all, it's quite clear that lower courts are completely ignoring the part where Scalia disparages the term prudential standing. They're just calling it prudential standing. They're not taking that signal. I think the strongest indicator that I've seen of whether it's being taken up is whether you see this analysis in trademark claims, right? So 43A1A sits right next to 43A1B. Are people mentioning Lexmark? They should be, because of that very clear instruction the court gave. Not yet, but I can imagine it coming.
Professor.
So I think I know what Thomas's answer is, but the actual label. What do we think about this label? If you read it, I mean, it's accurate, right? It says blend of 5 juices. It just mentions pomegranate, blueberry. It's not the largest lettering of the words that are mentioned. So do either of you have a take on whether you think that this constitutes false advertising?
I think it's misleading. I mean, when you look at the different bottles in the grocery aisle, and I've taken a look at that, I was actually surprised when I read the fine print of how little pomegranate and blueberry was part of that drink. And when that drink was specifically, I think, designed kind of to compete with POM Wonderful, which is entirely pomegranate juice and blueberry, I think the way in which it's marketed probably is misleading.
Yeah, I was particularly struck that Justice Kennedy at the oral argument seemed incredibly convinced that this was a fraud. I mean, and the wisdom is that despite the stuff about the reasonable consumer, like if you go in and the judge thinks that it's deceptive, it's gonna be deceptive, and that clearly was what happened at the oral argument.
And this is Justice Kennedy. Yeah, Justice Kennedy, he asked if Coca-Cola stands behind this label as being fair to consumers. He said, quote, "I think it's relevant for us to ask if people are being cheated in buying this product." And then near the end of the argument, Coca-Cola's counsel said, "We don't think consumers are quite as unintelligent as POM must think they are." And Justice Kennedy said, "Don't make me feel bad because I thought that this was pomegranate juice." So I think people definitely left that argument saying that you knew what one vote was.
Any more questions? No? Well, let me be the first to thank our panel today on this very insightful conversation.